The only people who don't want to disclose the truth are people with something to hide.
But there was a strenuous effort to try to get it so that it's just 35 years of age and 14 years of residency, and to eliminate the natural.
When you started this case,
yes.
Was it in the nomination process at the time?
The nomination was completed back by March, and to be real honest, I was waiting for somebody with far deeper pockets for one thing, but far more expertise, experience, and to come forth and take care of it.
I'm just wondering if it's not ripe during the nomination process when it's.
Well, the problem is, if it's ripe or not, you'll never make it all the way through the process. Because, I mean, in this case, we're over 9 months, and some of the other. When did the light just go on, or it's been on?
You can finish your thought.
The issue of ripeness certainly came to mind. Somebody the other day mentioned to me that the best case to chat about in relation to this would be Roe v. Wade. The individual Roe, in fact, and her attorneys only had basically 9 months to bring the case before, through the whole judicial process. Of course, 2.5 years later, they were still laboring away at it.
Okay.
Similarly here, I would have 6 or 7 months at best to make it all the way through the process, and we may be another. We're 9 months in at this point. Could go much further.
Okay.
But
thanks very much. Thank you very much. Thank you, counsel.
Good morning, Your Honors. May it please the Court. Todd Delos representing the State of Vermont and the Secretary of State.
And I take it not Barack Obama?
Not Barack Obama, Your Honor.
Do you understand right that there was or was not service? I wasn't clear from the answer of Mr. Page on that he said he went through various means of service and he accomplished those. Do you understand there was service under the law?
There was not service under the law, Your Honor. And in fact, as early as September 12th, the trial court judge in this case filed an entry order suggesting that service on the President was going to be a significant challenge for Mr. Page. Ultimately, service was not accomplished as Mr.
Can it be done? I don't know anything about this. Can the President just say, I'm sorry, I would never appear in response to a suit in the Vermont courts?
I wouldn't know how the President would respond personally. I know that Presidents have been sued in the past, that Mr. Obama was sued in similar suits. I mean, this is one of 200 different legal actions challenging the President's qualifications to hold office based on his birth. This is not a novel claim, and it is not a particularly distinct claim, though Mr. Page points to sections of Vermont law where he suggests he can obtain standing, contrary to most plaintiffs in actions of this sort. That reliance is misplaced.
Well, he says this is not a birther claim, and these other claims I assume that you're referring to would fit more neatly into that box. But what's the difference? I don't understand what the difference would be.
I wouldn't claim to be a birther, Your Honor, so I couldn't parse the language exactly. But what I would suggest is that a birther claims that Mr. Obama was not born on U.S. soil, and a natural-born citizen, I'm not quite sure what the short phrase for that is, but Mr. Page's argument is that there is an archaic definition used by a Swiss writer in the mid-1700s that suggested that a citizen had to have both parents be that in order to be a natural-born citizen, an individual's parents both had to be citizens at the time.
So out of that 200, is there some number of those that fit into this second category?
I have to admit that the last I checked, I got 3 pages here that are natural-born citizen suits. Okay. So I'd say it's roughly 50.
Yep.
And they're not necessarily separate. I think there are probably suits where both.
And they're somewhere in the process, or they've been dismissed. I don't recall in the briefing that we were directed to any of this particular litigation. I mean, we were directed generally on the case, but not to this. So what has happened to these 50 cases or so?
When last I checked, Your Honor, I believe as of April 3rd, 201 had been dismissed and 207 were still in process. 207 had been filed, 201 had been dismissed, and 6, I believe including this one, were still in process.
Were any dismissed for lack of service?
The argument was raised, and in certain instances, I believe there's a case out of Washington in late August of last year, right around the time Mr. Page filed this suit, that the court relied on that, among other things.
And I'm sorry, you probably said this, but these are all cases filed in state courts, right?
Various different tribunals. It's not solely state court.
Including some
federal, some administrative bodies. It depends on the state law and where the plaintiff chose to file.
So are there any thoroughly reasoned standing decisions out there?
Several. Many of them most of them are in federal court. Hollander versus McCain originally out of the District Court of New Hampshire, is a fairly well-reasoned case. But the trial court judge does a good job of pointing to several of them. Berg versus Obama is another. Those all deal with federal questions of standing, and largely this court has found the same standards of standing, and in fact has adopted in Parker federal standing. Mr. Page also raises the point of Title 17, Section 2603, providing him standing. The trial court pointed out that the specific provision that Mr. Page is relying on, subsection B, Section 3, which suggests that a contest of an election can be filed for any other reason, claiming the result of the election is not valid. Mr. Page would argue that means you can file anyone who voted, any voter, can file any claim of any sort challenging any election in the state. And I believe that draws that statute far too broadly. Not only is election a defined term within Title 17, 2103 of Title 17.
Who, in your view, would have standing for this kind of question? Make it less global, make it just a state representative whose the allegation is lives outside the district and living in the district is a requirement. Who would have standing for this kind of case?
Well, that particular hypothetical is difficult because Vermont's Constitution specifically grants the General Assembly or the House of Representatives the authority to determine the qualifications of any member, and therefore this court has held that the case is called Kennedy, that in fact this court doesn't have. So
it's your client, Mr. Kondo. And there's some technical, he's really a resident of Florida. So I know there was some allegation of that, I think, with respect to the auditor accounts at one point. I'm just making it up just to understand who would have standing.
But if I was a candidate and I thought my opponent didn't have meet the eligibility requirements under the state law for whatever state office I was running for, I'd have standing, wouldn't I?
Certainly it has been suggested in the federal cases that the candidate's challenger would have standing, potentially under a theory of competitive disadvantage. I wouldn't know exactly how this court would rule on that, but I would imagine following the federal precedent as this court has in the past for Article 3 standing, that would follow.
And you said that's Kennedy?
Kennedy is the case involving the House of Representatives. That was a specific challenge about, I believe, a vote.
So back on the standing, so the only one you can point me to is an opponent as a possibility for standing, and even there, that's just a possibility.
Well, actually, how about the opposing political party?
I think
as challenging the eligibility of a candidate from another party.
I think it would depend on the specific allegation and whether there were constitutional rights involved. Specific to this case, the difficulty is Mr. Page is attempting to gain standing either as a general voter, claiming that his injury, well, it's not entirely clear to me exactly what his injury is, but
wait a minute though. Why isn't that a legitimate basis as an ordinary voter? Why wouldn't a voter have a right to challenge standing in order to make sure that the exercise of the prerogative to vote is meaningful, has some meaningful result?
Well, Your Honor, I think it depends on exactly what the challenge is, but the rules of standing, the constitutional requirements of standing require a specific injury and not a generalized grievance. And generally speaking, as with a taxpayer, a voter would have no more than a generalized grievance. If it was a concern about the conduct of the election, there was fraud, I was threatened by a mob outside and wasn't able to vote, certainly that would provide a specific injury and standing, and arguably that is what 2603 was meant to remedy, was to allow those voters not to have to deal with standing, but in fact to get before a judge and say that there's a case from 1948, for example, where the opposing candidate alleges the lighting was bad and therefore people couldn't read the ballots. That's the sort of challenge.
Don't we as voters have a more direct interest in the purity or lack of corruption of the ballot itself as opposed to some generalized challenge against a policy adopted by statute that really has nothing to do with us directly? I mean, don't we all have a direct interest in who we vote for?
Well, certainly I would argue that the qualifications of a candidate are best vetted by the voters as opposed to any other tribunal. I'm not sure if that's the question Your Honor's asking there. The purity of the ballot, meaning the actual piece of paper, or the purity of the ballot?
Well, the purity of the candidates, the fact that they're supposed to be there or not.
The integrity of the system. How about if you phrase it that way?
I think all voters have an interest in that, but that doesn't provide any given voter with standing to address the issue, because so the reason standing doctrine prevents that sort of generalized grievances, there's no guarantee that the individual who is litigating the case will litigate it with the authority of all the injured parties.
But then there's no reason to have qualifications, right? There's no need to have a provision requiring citizenship for candidates, because no one will ever have, well, hardly anyone will have a basis to complain.
Well, arguably the individuals most deeply impacted, those who didn't get a job because they were voted out of office or some portion of their vote was siphoned off because of an unqualified candidate, they would in fact have standing, or arguably would have standing, to challenge that
I take it in the system Mr. Condos cannot be encouraged to, or will not make this determination himself. So let's say Mr. Page goes to Mr. Condos right away and says, Mr. Condos, do not put on the ballot Barack Obama. It would be a violation of the United States Constitution for that to happen. I take it in those circumstances Mr. Condos says, this is I don't have a dog in this fight. This is not my fight. I'm not going to make that determination.
It's not even clear that he has the authority to do that. Under the law, it's expressed that when the Secretary of State, I guess there are two answers to that. The first part is I don't think under the law that the Secretary of State has the authority to make that call. Secondly, and this is a quote from Keyes versus Bowen, which is a California Federal District Court case from appellate court case. The court, in dealing with exactly that question and the argument of whether or not the Secretary of State should have the role of determining qualifications, said the truly absurd result would be to require each state's election official to investigate and determine whether the proffered candidate met eligibility requirements of the United States Constitution. Essentially, it would subject the presidential nominating process to each of 50 states' election officials, all of whom are politically elected, independently deciding whether a presidential nominee is qualified.
Isn't the fact then the independent election official can't contest this question, doesn't that sort of support the notion there must be standing somewhere to do it, and that it would therefore be more appropriate to let the voters bring suit? Because in the normal circumstance, of course, you would say about standing, well, there's a independent elected official, there is a appointed official, there is an official who looks at this question, decides it one way or the other. You might be able to get review of that official's decision. That's another issue involved, but there's an avenue. Here, what you're saying is there is no avenue. In the absence of an avenue, shouldn't we take that into account for standing?
I guess I would. I apologize if I've given the impression there is no avenue. Specific to this case, Mr. Page doesn't have standing because Mr. Page is a voter. There are other avenues through which one may potentially be able to challenge this in federal court. In the first instance, the voters are determining the qualifications of any candidate through the voting process. In the second place, a challenger who believed that they were facing an unconstitutionally qualified candidate potentially could bring suit. But I think ultimately it is Congress's role, and a role that has been dedicated to Congress, to determine these issues. Now, whether or not, if you were to liken this to an environmental case where I live in an area that is going to be flooded by a potential dam, that may give me standing, but if I simply enjoy the view of a valley that will potentially be flooded, that doesn't provide me with standing. There may be a regulatory authority who should be looking into that, but they may not be doing it. That doesn't mean that I as just someone who enjoys the environment should get standing. It's the same circumstance here with a voter. Simply because the voter believes that a candidate is not constitutionally qualified doesn't provide them with standing, even if there isn't necessarily a ministerial actor within the government who is given that role. If there are no further questions, Your Honors.
Okay, thanks.
Appellant has no time remaining for the next hearing for the court. It's scheduled for 10:30 this morning.
Excuse me, before you guys